one of your esteemed colleagues has said, Bullet, that in fact basic structure, those theory is also doubtful. Maybe
Mr.
it is.
Sibal, when we refer to a colleague, we have to refer to a sitting colleague. Once we cease to be judges, they are opinions, not...
Doesn't discuss what goes on in the court.
No, I'm not discussing anything.
I am not discuss what goes on in parliament.
No, I'm not discussing.
Everyone, my lord, has a freedom of...
This is a public
view. After 2019 exercise, approximately 1,200 laws are now applicable. All beneficial legislations.
Therefore, if that part of the notification, which amends 367, is kept aside for a moment, then what is the consequence?
The consequence is that 356 power cannot be exercised in the same fashion.
No.
To achieve the same result.
See, the 356 power is the power of the state legislature and the state executive, which has now been vested in the president and in parliament, respectively.
Correct.
You may be right for a moment, subject to hearing them, that look, how can you exercise the power to amend the constitution by taking recourse to 356? Fair enough. We got that point and we'll hear them on that. But assume that we disregard this whole process of what took place under 367. Either disregard it or hold that it was constitutionally impermissible. Even so, does it affect?
That's a separate issue, Malad. I'll address your lordships on that.
Right.
At the moment, I'm on this executive order. I'll come to 356. I'll come to the other issues later, Malad. Because ultimately, what you then do is Parliament is exercising power as a legislature, and Parliament is exercising powers under 356 as well. Correct, Malad? And as a legislature of the state, let's assume, the state had to convert itself into a constituent assembly in terms of 373.
I think what they believed was they proceeded on a particular hypothesis that consultation with the constituent assembly is necessary.
That's right.
So therefore, they said that, all right, we are now going to replace the word constituent assembly by the word legislative assembly. Which they sought to achieve by amending the constitution.
No, it's a recommendation of the constituent. It's not just converting it. You can't.
The first step was to amend the constitution.
Yeah, you recommend it to yourself because you have a political objective to recommend it, and Mullahs, you take the decision yourself.
Yes.
This is very problematic, Mullahs. And see the consequences of this. That means through an executive order, you can change any provision of the constitution because you have majority. But this majoritarian culture cannot destroy the edifice of what our forefathers gave us.
So your argument, therefore, is that you cannot exercise the power under 356 to amend the constitution.
Exactly.
That point you...
That's right. And they cannot possibly justify it unless there is some new jurisprudence that comes to light that they can do what they like as long as they have the majority. As it is, Mullahs, now one of your esteemed colleagues has said, Mullahs, that in fact basic structure, those theory is also doubtful. Maybe
Mr. Sibal, when we refer to a colleague, we have to refer to a sitting colleague. Once we cease to be judges, they are opinions, not binding diktats.
That's true. Of course, it's not binding, but I'm surprised.
On 11th of November 19...
Parliament doesn't discuss what goes on in the court.
No, I'm not discussing anything.
I am not discuss what goes on in parliament.
No, I'm not discussing.
Everyone, my lord, has a freedom of...
This is a public
view, freedom of expression.
No, I know. Mulad, I assume he has the freedom of expression, what he likes. I don't dispute that, Mulad. I'm just saying, Mulad. Of course, absolutely. We're starting a debate on that because of this majoritarian culture again.
Mr. Sibal is responding to the parliamentary debate here because possibly he was not there in the parliament yesterday.
That is true. That is absolutely true.
It was that place where he could have expressed his views on basic structure.
Not my view. My view is clear because my view is the court's view. I can't go beyond that. But I am an officer of the court, Mullah. In court, I have that constitutional view. Outside, may have a different view. Anyway, that's neither here nor there, Mullah. It's just an aside, Mullah. There must be some element of humor and mirth in court as well, Mullah. Not everything can't be this serious. We are
Yes,
dealing
Mr.
with-
Pillai.
Therefore, see the consequences of this. And then it is obviously clear that the government of India and Parliament recognized that the Legislative Assembly was the Legislative Assembly and could not be the Constituent Assembly, which is my interpretation. Therefore, it became necessary because they also knew that the Legislative Assembly can't be the Constituent Assembly. That's precisely what I've been arguing. And it says shall read. This is an interpretation clause. Please appreciate 367 is an interpretation clause. It's not a clause to substitute definitions. If you look at 367, the heading is interpretation. It's not substitution. You can't substitute definitions. You can only interpret. So it's outside of 367 itself, apart from many other things that I've pointed out.
What they've done is
Provided that in respect of any period to the 10th day of April 1965, such references shall be construed and including references to the Sadr-e Riyasat acting on the advice of the Council of Ministers. Because originally the Sadr-e Riyasat had to, till 1965, had to be appointed on the recommendation of the Assembly. A name would be sent and they would agree. In 65, a change was made, in terms of which, Malaz, the president could directly appoint the government. That change happened in 1965 in the Constitution of Jammu and Kashmir. So like any other state. So slowly, in any case, Malaz, there was a slow but sure obliteration of the kind of autonomy that Jammu and Kashmir enjoyed. All laws were applicable, including TADA, POTA, UAPA, all laws are applicable there, except for land laws and personal laws. Most laws of India are applicable there at that point, in this point in time, in any case. So there was actually no need for any of this, except with the objective of sending a political message that we have done away with 370. That's why all this was done. Now, that's my submission.
After 2019 exercise, approximately 1,200 laws are now applicable. All beneficial legislations which are available to other citizens now are available to Jammu and Kashmir also. Prevention of Corruption Act was not applicable. Right to education.
There was. My learned friend is not right.
Several laws.
Anyway,
we have the list.
Let's not go into that. Let's not go into that. Prevention of corruption law was applicable.
You are right, Mr. Dwivedi. That's not a constitutional point. But
political optics, all laws were applicable.
Just to set the record right, the Jammu and Kashmir Prevention of Corruption Act, somewhat 2006, applicable. So it's because they were named differently. Anyway, let's leave that. Let's not.